Welcome again to the best family law podcast in Florida by Jacob's Law Firm. A quick disclaimer, nothing said here is legal advice. This is simply entertainment, informational, and referential. All right, here's a free lesson, ladies and gentlemen. A motion is not a pleading. How do I know that? Because it's written in the rules. A motion is not a pleading. There is a distinction. This is of the utmost importance in family law. Why is it so important? A motion is asking the court to do something. A pleading is a petition, a counter petition, an answer, a supplemental petition. There are accompanying documents, the child custody affidavit, financial affidavit, notice of social, things like this. But a motion is not a pleading. And of course, this has been well explained by just about every district court of appeal. But recently in 2024, a case came up upon appeal. A party asked the court for absolute majority 100% timesharing to modify the schedule, to modify a final judgment, a timesharing plan. The trial court mistakenly gave the father in this case 100% timesharing with the minor child. And of course, that might be fine if there's an emergency motion due to neglect or imprisonment or something, but it's not supposed to modify a parenting plan. It's merely temporary. In this case, the entire timesharing plan was essentially modified. That can only be done through a petition. Yes, a supplemental petition, but bear with me about the technicalities, the nomenclature. Only a petition, and upon a petition, can a timesharing plan / final judgment ordered by the court be changed. In the absence of having an open petition in which the court changes the parenting plan and final judgment, you cannot do that. There can be a temporary order, yes, but not a final order based on a motion. A motion asks the court to do something, but it cannot change a final judgment. Therefore, the District Court of Appeals had to come in, and even though the minor child's best interest might have been giving that parent 100% sole and exclusive child custody timesharing, the District Court of Appeals had to clarify that the trial court, and no court has the authority to change an entire parenting plan based just upon a motion. There needs to be more. And what more is that? The filing of a supplemental petition for modification of final judgment and parenting plan and or child support. This is of the utmost importance to know. This is of the utmost importance for you to recognize and realize. While I cannot apply this law to your specific case, as that would be giving legal advice, it's obvious that simply filing a motion to ask the court to do something, especially on a temporary basis, but you cannot change an existing parenting plan and final judgment based only on a motion. A motion is not a pleading. Only upon a pleading, such as a supplemental petition or a supplemental counter petition, can this relief be given. And if you approach your case in this manner, there could be consequences. There could be a negative impact and a negative fallout, one of which is if the trial court rules properly, your case might be severely delayed. This has been the best Florida Family Law podcast by Jacob's Law Firm. I'm attorney Jonathan Jacobs. I'm glad you joined me for this brief lesson, and I hope you learned a little bit of information that maybe you can utilize, look up, research on your own, or call us about, and then it will help you have a broader perspective on family law and the court rules.